I was halfway through a federal sentencing memo when my phone started vibrating nonstop on the desk. I ignored it at first. When you've been a federal judge long enough, you learn that most emergencies can wait 5 minutes. But then I heard the knock, sharp, official, the kind meant to be heard. I opened my front door to find a man in a polo shirt with an HOA logo stitched over the chest, flanked by a uniformed sheriff's deputy. The man didn't introduce himself. He didn't need to. He handed me a thick envelope and said, with rehearsed confidence, "Sir, this property has been seized by order of the Homeowners Association. You have 48 hours to vacate." I looked past him at the deputy. The deputy wouldn't meet my eyes. Inside the envelope were notices stacked like a deck of bad cards. Fines, violations, liens, and finally the bolded headline, foreclosure authorization. According to the HOA, I had failed to pay escalating penalties for unauthorized structural modifications and noncompliance with community standards. The total amount listed was absurd. Tens of thousands of dollars. Interest added daily. Enforcement fees layered on like punishment. The most interesting part wasn't the amount. It was the assumption. They assumed I would panic. They assumed I would argue. They assumed I would beg. Instead, I calmly asked, "Can you tell me exactly who authorized this?" The HOA rep puffed up a little. "The board," he said. "We've been patient long enough. This neighborhood has rules. Nobody is above them." That line almost made me smile. What he didn't know, what none of them knew, was that I had purchased this house quietly years earlier through a blind trust, specifically to avoid attention. No plaques. No titles. No neighbors asking questions. Just a modest home, good light, and enough distance from the courthouse to let my mind rest. I thanked them for the paperwork, closed the door, and went back to my desk. I didn't call a lawyer. I didn't call the HOA. I didn't call the police. I opened a different file. You see, one of the benefits of spending decades on the federal bench is that you develop an intimate understanding of how authority works and how fragile it becomes when it overreaches. HOAs love power. They thrive on paperwork and pressure. But they only function when people believe they're untouchable. That belief was about to collapse. By the next morning, bright orange seizure notices were taped across my garage and front gate. Neighbors stood at a distance, whispering, filming on their phones. Rumors spread fast in planned communities. Some said I was a criminal. Others said I was bankrupt. The HOA president even posted a smug update on the community board about finally enforcing compliance. Still, no one bothered to knock again. They thought the story was over. It wasn't. Because while they were celebrating their authority, I was drafting something very different, a timeline, a jurisdictional analysis, and a paper trail that showed exactly how an HOA had crossed from civil enforcement into federal violation territory. And once that line is crossed, there's no walking it back. By noon the next day, the HOA president finally reached out. Not by phone, not in person, by email. The subject line read, "Urgent. Immediate compliance required." The tone was smug, formal, and careless all at once. It referenced bylaws, enforcement authority, and something called community sovereignty, a phrase that has never meant anything in any court of law. They informed me that if I attempted to interfere with the seizure, additional penalties would be assessed, including forced entry to secure HOA assets. That sentence is where they made their first fatal mistake. Forced entry. I printed the email, highlighted that line in yellow, and placed it neatly on top of the growing stack on my desk. Then I opened a new document and titled it simply, HOA v. Federal Jurisdiction Preliminary Notes. Here's the thing most HOAs don't understand. They are private corporations with extremely limited authority. They rely on consent, contracts, and fear. The moment they step outside those lanes, especially into property seizure, impersonation of law enforcement, or interference with protected roles, they expose themselves to consequences they cannot insure against. And this HOA? They were sprinting outside the lanes. At 2:17 p.m., I received another notification. The HOA had instructed a towing company to prepare for removal of assets from my driveway. My vehicle. My property. Without a court order. I picked up the phone for the first time. Not to warn them, to document them. I called the county clerk's office and requested certified copies of the HOA's incorporation documents, enforcement scope, and any recorded liens. Then I called the sheriff's department, not to complain, but to ask a very specific question. Under what authority did your deputy accompany a private entity during a foreclosure notice? There was a long pause on the line. That pause told me everything. By sunset, the neighborhood Facebook group was in chaos. Someone had posted that the HOA might be dealing with a government official. Another claimed I was connected to Washington. The HOA president responded aggressively, assuring everyone that no individual status overrides HOA rules. That was their second fatal mistake. Because status doesn't override rules. Jurisdiction does. And they were about to learn which court actually mattered. At 8:03 p.m., I sent exactly one email. No threats. No titles in the signature. No emotion. It went to the HOA board, their management company, and their retained counsel. The body contained 3 paragraphs. A factual summary of their actions. A list of federal statutes potentially implicated by those actions. A request for immediate cessation of enforcement pending review. Attached was nothing but a single-page PDF. My judicial identification. I did not explain it. I didn't need to. Within 9 minutes, my phone rang. Unknown number. I let it ring. It rang again. Then again. By the 4th call, I answered. The voice on the other end was no longer confident. It was tight, controlled, trying very hard not to panic. Sir, the HOA president said, there appears to have been a misunderstanding. That was their 3rd fatal mistake. Because misunderstandings don't involve seizure notices, deputies, and forced entry language. Violations do. I told him calmly that all further communication should go through counsel, that no representative of the HOA was permitted on my property, and that any additional enforcement attempt would be documented as intentional. He tried to speak. I ended the call. Outside, someone had already begun peeling the orange notice off my garage. Slowly, quietly, as if hoping no one would notice it had ever been there. But I noticed. And so did the law. By morning, the notice was gone from my garage. So was the confidence. But arrogance has a strange way of resurrecting itself inside HOAs, especially when pride gets bruised in front of an entire neighborhood. Instead of standing down, the board held an emergency meeting at 9 a.m. in the clubhouse. Doors closed. Minutes unrecorded. Phones buzzing nonstop. That meeting is where they made the mistake that turned a bad situation into an irreversible one. They voted to proceed. Not quietly. Not cautiously. Proceed. At 10:46 a.m., I received notice, this time from their management company, that the HOA would resume enforcement actions pending clarification of claims made by the homeowner. They stated that my identification was unverified and that no documentation had been provided establishing immunity from HOA governance. That sentence told me everything I needed to know. They thought this was a bluff. They believed federal authority was a costume someone could put on to scare volunteers and property managers. They assumed this was a jurisdictional argument they could bury in paperwork and delay tactics. They were wrong. At 11:12 a.m., a tow truck rolled into the neighborhood. Slow, loud, impossible to miss. Neighbors came out onto porches. Phones came up. Someone started recording. The HOA president stood near the clubhouse with crossed arms, flanked by 2 board members, wearing the expression of someone who thinks they're calling a bluff. The driver walked up my driveway. I stepped outside and asked for the work order. It listed the HOA as the authorizing entity. No court order. No lien. No sheriff present. I asked him if he understood he was being instructed to seize property from a federal judge without judicial authorization. His face changed instantly. He made a call. While he was on the phone, I made one too. Not to law enforcement. To Chambers. Within minutes, the situation flipped. The sheriff's department arrived, not for me. For the HOA. The same deputy who had accompanied them the day before now stood stiff, avoiding eye contact, as a superior officer reviewed the paperwork. The tow truck driver quietly backed down the street and left without hooking a single chain. That should have been the end. It wasn't. Because humiliation does dangerous things to people who are used to authority without accountability. That afternoon, the HOA president sent out a mass email to the community accusing me of impersonation, threatening behavior, and attempted intimidation of volunteers. He urged residents to stand united against federal overreach and announced that the board would seek judicial clarification immediately. They finally said the word that mattered: judicial. What they didn't realize is that by accusing a sitting federal judge of impersonation and intimidation without evidence, they crossed into territory far more serious than HOA fines or property disputes. Defamation, interference, false reporting. And they did it in writing.
Publicly.
I didn't respond. I forwarded the email to exactly 3 people. By 5 p.m., their retained counsel resigned. By 6:30 p.m., the management company terminated its contract, effective immediately. By nightfall, the HOA president's phone number disappeared from the website. Neighbors began knocking on my door, not to complain, but to ask questions. Quiet ones, nervous ones, the kind that start with, "I didn't vote for this," or "Is our property safe?" I told them the truth. This was no longer about fines or houses. This was about whether a private organization could unlawfully seize property, misuse law enforcement, and retaliate against a federal officer, and then survive the consequences. The answer was already unfolding. The HOA filed first. That was their final mistake. 2 days after the tow truck incident, a civil complaint appeared in the county docket, filed by the HOA president pro se, because by then no licensed attorney would touch it. The filing accused me of impersonating a federal judge, obstructing HOA governance, and intentionally intimidating volunteers through false claims of authority. They thought filing first gave them control of the narrative. What it actually did was drag their conduct into a legal forum where facts, not ego, decide outcomes. The clerk flagged the case immediately. Not because of me, because of the filings attached. They included copies of HOA emails, enforcement notices, and, astonishingly, the mass email accusing me of impersonation. They submitted it as evidence.
Signed.
Dated. Distributed to over 300 homeowners. They handed the court their own confession. The moment the case was assigned, jurisdiction shifted. Quietly. Efficiently. Within hours, the HOA received notice that the matter had been reassigned to a different division and that all enforcement actions were stayed pending review. That stay applied retroactively, meaning every fine, lien, and seizure attempt was frozen in place. Then came the summons. Not for me. For them. The court ordered the HOA board to appear and explain 3 things. Why they attempted to seize property without judicial authorization. Why they involved law enforcement under false pretenses. Why they accused a federal officer of criminal impersonation without evidence. Those questions aren't procedural. They're existential. By the morning of the hearing, the HOA boardroom looked like a wake. 3 board members didn't show. 1 resigned by email at 6:14 a.m. The president arrived alone, carrying a binder so thick it looked defensive rather than prepared. She tried to speak first. The judge didn't let her. Instead, the court asked for verification of my credentials. I stood, identified myself, provided Chambers confirmation. That part took less than 30 seconds.
Then the tone changed.
What followed wasn't a hearing. It was an autopsy. The court went through their actions step by step. The fines, the seizure notice, the tow authorization, the email, the false statements to deputies, the refusal to stand down after being warned. Every time the HOA president tried to explain, the explanation created a worse problem. We didn't know became negligence. We were enforcing rules became overreach. We thought he was lying became reckless disregard. And when she said, "We were just trying to protect the community," the judge stopped her cold. You don't protect a community by ignoring the law. Silence followed. Then the court did something HOAs fear more than lawsuits. It ordered discovery. Full discovery. Emails. Internal messages. Meeting minutes. Financial records. Insurance communications. 30 days. No extensions. That's when the dam broke. Within a week, homeowners began receiving notices, not from the HOA, but from its insurer. Coverage was being reviewed due to intentional acts exclusions. Translation: if the board knowingly broke the law, the policy wouldn't pay. The president resigned. The treasurer quit the same day. The remaining board members hired separate counsel, paid out of pocket. And buried in the discovery was the document that ended everything, an internal message sent after they confirmed my identity, instructing the management company to proceed anyway and force compliance. That message meant intent. And intent changes everything. By the time the follow-up hearing arrived, the HOA didn't argue. They begged. But courts don't negotiate with private organizations that abuse authority and retaliate against protected officials. They issue orders. The courtroom was quiet when the final order was read. Not tense. Not dramatic. Just final. The judge didn't raise their voice. They didn't lecture. They didn't grandstand. They simply read the findings into the record, slowly, carefully, like someone documenting the end of something that no longer deserved to exist. The court found that the HOA had willfully exceeded its authority, falsely invoked law enforcement, attempted an unlawful seizure, and retaliated after receiving direct notice to stop. That last part mattered most. Because ignorance can be forgiven. Intent cannot. The order came in layers. First, every fine, lien, and enforcement action against my property was void ab initio, legally treated as if it never existed. Second, the HOA was barred from taking any enforcement action against any homeowner until further notice. Then came the part that made the president's lawyer close their binder. The court found the HOA board members personally liable for actions taken outside their authority. Not the association. Not the insurance company.
Them.
Individually. The judge cited the internal message, proceed anyway and force compliance, as proof that the board knowingly violated the law after confirming my identity. That stripped them of every protection they thought they had. Indemnification?
Gone.
Insurance coverage?
Denied.
Corporate shield?
Pierced.
Finally, the court addressed the structure itself. The HOA had been operating under a charter that required lawful governance and good faith enforcement. The judge ruled that the board's conduct constituted a material breach of that charter. And when a private organization materially breaches its own governing authority, the court has one remedy left: dissolution. The HOA was ordered immediately dissolved, placed into receivership for winding down, and permanently barred from reforming under a successor entity. No rebrand. No new board. No second chance.
Just done.
The judge ended with a sentence I'll never forget. Authority is not power. Authority is responsibility. When responsibility is abused, authority is revoked. Gavel down. That afternoon, homeowners started knocking on my door, not angry, not afraid, just stunned. People who had paid fines for years. People who had been threatened, bullied, silenced. They wanted to know what happened. I told them the truth. Nothing special. The HOA assumed they were untouchable. They assumed titles only flowed one way. They assumed the law was a weapon instead of a boundary. And they never imagined the person they tried to intimidate understood that boundary better than they ever could. My house was never seized. Their authority was. And once the law takes it back, it never gives it back.